Good afternoon. We are, my name is Bill Fisher, and I am a federal bankruptcy court judge. Before that, I was a Hennepin County State Court judge. And I'll be joined later by Judge Tanya Bransford, who is a Hennepin County State Court judge. And what we're going to do is we're going to talk about lynchings that occurred in Duluth and a subsequent trial as well. We're going to talk about that and afterwards and what should have happened and how our Constitution should have protected people, but failed to in that instance and many other instances like it. And so what we're going to do first is show you a PowerPoint presentation and about the lynchings, and we'll start that right now. And my law clerk, who's a lawyer, David Tanabe, will start the start the PowerPoint, and then we'll have a more discussion when we're finished. And while it's getting ready, I'll give you a bit of a highlight here that first of all, our speaker on this PowerPoint will be Jerry Blackwell, who actually tried the Chauvin case on behalf of the state, was one of the attorneys on behalf of the state. And so that's the voice you'll be hearing. And he also was involved with getting a pardon after the death of a man, Max Hastings, Mason, who was actually convicted of the crime involved here in a trial, but he got pardoned after his death. And he was involved in that pardoning process. And hopefully we'll get this started shortly.
You know, it's roughly about a year and a half ago that Corey Gordon and I were sitting around thinking about what good we could do, what might be a project that we could take on that would help to improve the society around us. We figured punching at shadows never makes them go away, so what light might we be able to bring? So drawing attention to the 100-year anniversary of the lynching in Duluth is what we arrived at. And seeking the pardon of the only person convicted for the fictitious rape, a young black man, Max Mason, was also going to be our focal point. We figured that there really are a few principles in our society more important than equal justice under law. So under the sort of notion of rubric that we all are responsible for understanding the connections between our history and our present moment, or else we remain in this sort of destructive cycle. I think that's the way James Baldwin put it. So it did ultimately take the entire village, the village of the state of Minnesota, to achieve this posthumous pardon, as no posthumous pardon had either been sought, much less granted before. So we wanted to do this to clear the good name of Max Mason, a young man who was put into Stillwater prison in his early 20s. He was, I think, maybe 23 or 24 years old, young man. He actually passed away young also at 46 years old in Tennessee. We wanted to do it for the public good. That is to help to affirm the commitment of the state of Minnesota to equal justice and the rule of law. And we thought there was something cathartic about addressing this issue, bringing it to the surface, and helping to bring a greater sense of reconciliation and healing within the Duluth community and our state around us. So as you all probably know, the power of the pardon. The pardon is the power of the pardon board to pardon people who are under investigation, who have been charged with a crime or convicted of a crime. And it's usually done for one of two reasons. One is for the public welfare, and the second one being mercy. And even as you might recall, President Ford pardoned President Nixon because he wanted to get Watergate behind the country, and he felt the priority should be to unify the nation. So we felt that for the public good, Max Mason should be pardoned. So you can see here the first slide is a slide of the John Robinson Circus coming to town. It was only in town on Duluth for just a day, June 14th. If you go to the next slide. And let me fill in some of the lines in terms of what the backdrop is of what happened. As it was, there was accusation of rape by the young Irene Tuscan, who was herself in her late teens, 18, maybe 19 years old. And her boyfriend, who was a few years older, James Sullivan, made this claim that in 1920, on the night of June 14th, that Irene Tuscan had been raped by any number of the young black men who were part of the circus. The circus was packing up that evening to move on from Duluth to head on to Virginia, Minnesota. But it really took not much more than her accusation as a white woman to activate a Minnesota criminal justice system where there was a fuel of racism all around it at every step and stage that ultimately resulted in taking the lives of the three young black men and then snatching years of the life away from Max Mason, who was sentenced to serve up to 30 years of hard labor in Stillwater Prison. So here I want to talk a bit more about what happened. If you go to the next slide. So if you can picture back in this day when the circus had come to town, June 14th, 1920 in Duluth, there was a curfew in Duluth. The Duluth curfew whistle had sounded at 9 o'clock. You're supposed to get in and be in. But it was sometime around that time that Irene Tuscan and her boyfriend was still out. She had gone with a few of her girlfriends at about 8:30 to the circus grounds. She didn't go to the circus. She didn't go in the circus. She was just sort of around there, hanging out with just whatever the activity was as people were, in fact, exiting the circus. It was there that she connected up with her boyfriend, James Sullivan, and they went to hang out. She ultimately took a streetcar home sometime later that evening. It was late when she got in the night. Her father was up reading something. She said goodnight to him. Her mother was asleep, or at least in bed, so she said a good night to her mother, went in, washed up, and went to bed, and that was the end of it. At least far as Irene's part of the story was concerned. Now, her boyfriend, James Sullivan, worked the graveyard shift down at the docks, at the Duluth, Mesabi, and Northern Ore docks. And so he left his girlfriend and went home to change clothes. And then at 1 o'clock, there he was at work, and his father worked there too, his father, Patrick. And it was James Sullivan who first told his father that a gun had been put to his head and that his girlfriend, Irene, had been gang raped. Patrick Sullivan, the father, then called the chief of police, who was Chief Murphy, called him at home after 1 o'clock in the morning, telling him that some African Americans, except he didn't say African Americans, it was very pejorative and derogatory, that they had raped Irene Tuscan. So the whole account then comes from the boyfriend, where he says that around 10 o'clock at night, he and Irene were hanging out around the circus grounds somewhere in the back of the circus when 6 black men supposedly had confronted him and Irene as they were leaving the circus. He said that one of them grabbed his arm, another one placed a pistol to his head and threatened him to be quiet. And while he was being held hostage, the men dragged Irene to a clump of bushes where she was supposedly ravished. So that was all the police chief, Chief Murphy, needed to get right down to where the trains were leaving town on the way to Virginia. So he goes right there and gets on the train, then let the train take off. And he says, get out of here, you African-Americans, you. Except he didn't say African-Americans. He said something that's very pejorative, is what he said, including to Max Mason. And then he said that he wants to talk to every expletive that was idle between 9 and 10 o'clock last night. It takes all of the young black men off the train. So they were taken off then for positive identification. by either James Sullivan or Irene Tuscan. By now, they'd gotten her up and her family and gotten them down. So they, having stopped the train and boarded the train, they brought him off for positive ID. And when Max Mason was put in front of Irene Tuscan, she was asked, could she identify him? Is he one? She said no. She said he wasn't one. And she couldn't identify, in fact, anybody by face. But then later on picked out 5 men anyway, based on size and physique. Now, having done that, as specious as that might be, none of those included Max Mason either. So they asked her boyfriend, could he identify any of them? To which James Sullivan said, they all pretty much look alike to me. I don't know for sure. So the train went off. They did take off a number of the African-American men, the 5, not Max Mason. And the train goes on. They go on to Virginia. Well, the next day, they send additional police up to Virginia to try to make additional identifications to bring down more suspects. So Max Mason was apprehended a second time in Virginia, Minnesota. And so at this point, there is an officer there in Virginia who then pointed a pistol at Max Mason saying, talk, let's have the whole story. And so when Mason said he didn't know anything, the officer said, oh, you know plenty, all right. If you don't talk, I'll kill you. The officer then cocked the pistol of the gun and momentarily held it up to Mason's ear before putting the gun away. So Max Mason was being transported back as a suspect when the lynching in Duluth took place, which would have been on the night of June 15th. Now, there was a mob that had gathered for this. All during the day on June 15th, various hooligans had been roaming around Duluth, giving notice of a necktie party that was to be had. There was a Commissioner Murnian, who was the Duluth Commissioner of Public Safety, was of no help for the situation. In fact, he issued an order in the wake of the so-called necktie party saying that no guns or clubs should be used against the all-white mob. And he said, I don't want to see the blood of one white person spilled for 6 African Americans, except he didn't say African American. What he said was, I think. So after further interrogation, the police, they rounded up 8 other black men to number 13, who were going to ultimately be put into jail. But the second contingent that included Mason was interrupted. They weren't taken there, given the unrest that was taking place. So there were any number of the men that were brought into town in Duluth who were set free based upon the questioning at the Duluth jail. And but they kept 6 of the young African American men in custody. 5 they brought, plus others they had brought in there. So that is how you end up with a group that was still in the jail in Duluth. So if you go to the next slide. Now what you see here in the picture on the left, that's the Duluth police precinct with the windows busted out and so on. So there was a crowd that gathered there. There was a crowd of 10,000 white Duluthians who were there for the lynching. And at the time, Duluth was a city of only 100,000 residents all in. So 1 in 10 were actually there for this horrific scene. So the lynching did take place. They battered the jail. They busted a hole into the precinct, and then brought out Clayton Jackson and McGee. Had their own sort of makeshift court hearing and their kangaroo court assessment by the lamppost, and they killed those 3 young men, Clayton Jackson and McGee. Now, as horrific as this was, there was equally horrific media support for it after the fact. For example, a newspaper in Ely said the lynching was most effective, and those who were put out of their criminal existence by the mob will not assault any more young girls. And there were other similar kinds of reports made. Across the bridge in Superior, Wisconsin, the chief of police had declared, "We're going to run all idle Negroes out of Superior, and they're going to stay out," in response to the lynching. So it was in this atmosphere that ultimately the conviction of Max Mason took place for the rape of Irene Tuscan. If you show the next slide, you'll see here just a photo taken of some of the mass of humanity that had come together for the lynching itself, to witness it and to be in support of it. Next slide. And this is the actual picture of the lynching that took place, and the three young men who were killed. And we've to some extent blurred and muted the photo just because it is horrific to see. But what I really want you to pay more attention to than the young men who had been killed is the faces of all of those, or the faces of all of those who are standing around observing, and which is probably the most difficult thing ultimately to look at in this photo from the lenses of hindsight of today. These were individuals who wanted to be in a photograph for what they had done, and this photograph was converted into a postcard, so there would be mementos of what was done. Postcards sold out from the event of the lynching. Now, in the 10,000 folks who were assembled there, you have to bear in mind that it would have included all of the police officers who were then on duty. No doubt included judges who were then present, one of whom actually attempted to dissuade the lynching on the front end of its occurrence. And even members of the National Guard who were there on duty just blocks away. So if you go to the next slide. And this is simply the headline that was in the Duluth Herald the next day from the lynching. Another quote from James Baldwin is, you sort of look on this scene and this incident. This quote comes to mind for me, where he said, "The cowardice of this time and place, this era, is no more clearly revealed than in the perpetual attempt to make the public and social disaster the result or the issue of a single demented creature." And so it was more reflective of a society, although most certainly telling about individuals directly involved. But it came out of a place with 1 in 10 of the townspeople involved in it. So few members of the lynch mob received any kind of punishment at all. The two who did stand trial, Henry Stevenson and Louis Dondino, they served less than half of their 5-year sentences, and the sentences were for simply rioting. Nobody was convicted of the murder that 10,000 individuals had witnessed, and number of whom in support of, further. So, as we've alluded to, Max Mason was convicted of the crime of this fictitious rape. Now, what makes the rape believed to be largely fictitious? Well, not largely, simply fictitious. Within 12 hours of this supposedly occurring, the Tuscan family had a family physician, doctor, who came to examine Irene Tuscan. And he examined her very carefully, and he didn't find any instances of bruising, any tearing, no damage. And his comment kind of afterward was he doubted very seriously that any rape could have taken place, much less by multiple young men just hours before. And you did hear quite a bit already about the nature of the product of the identification of the so-called assailants. So if you go to the next slide. So this was actually another quote from the Ely miner that you can see, that I just bring in just to give some flavor of what was sort of prevailing mentalities around. At the same time, it was sort of a widespread sense, even in Duluth, that no rape had in fact taken place. There were misgivings about it from the beginning, from the trial judge to persons in the prosecutor's office to some of the newspapers around even very seriously questioned whether this even happened. But at the same time, this had been an act that had been supported by a great swatch of the community. And I'm certain it would have been difficult for community members to have to acknowledge within themselves at a trial that if Max Mason had done no wrong, nor had anyone, then there has to be some accountability for the wrongs that were done and the lives that were taken. And to some extent, Max Mason was a kind of referendum on that. And he was convicted and sent away for the 30 years. So if you go to the next slide. So as it was, the three young men who were killed, Clayton, Jackson, and McGee, were then they're killed in 1920, and their graves went unmarked until 1991. And in that intervening time, the lynching in Duluth was not widely taught in schools. It was not spoken of. It was largely hidden and forgotten. A St. Louis County Historical Society employee in the 1940s supposedly threw out the file on the incident and deeming it to be too unseemly for study by school students. And so when Minnesota history courses, they required for teachers in training to not mention the incident. The postcards that had been bought and sold out from the incident remained hidden away in various attics. And a lot of the men and women who were present that night wouldn't speak of it again. In fact, one of the police officers who was supposed to be defending the jail when questioned about it in the 1970s said he had no memory of that night. When it had to have been the most significant night in all of his policing career. And so it was that in 2003, in October 2003, the Clayton Jackson McGee Memorial was erected in Duluth, and that's what you see here in this picture. It was the first memorial in the country dedicated to acknowledging the victims of lynchings in the country. And the very first. And then just roughly a month ago, the Equal Justice Initiative, Brian Stevenson's organization, partnered with members of the legal community here, led by Chief Judge Thunheim, and with the Clayton Jackson McGee Memorial Committee, and erected a monument at the very spot where the lynching took place in Duluth. And so that was dedicated then roughly a month ago. It is kitty-cornered from the memorial that you see here, and on that monument you'd see a discussion of what took place at that scene 100 years before. So Mr. Gordon is going to show you a few exhibits from the hearing, from the trial. Of this, and we'll discuss the posthumous pardon process in some greater detail. So I'll stop and turn it over to Mr. Gordon.
And we're going to end there with that, and we'll get that off the screen in just a moment. We're not going to learn about the about the pardon process today. We have been joined by Judge Tanya Bransford, who is a Hennepin County judge. And you're the most senior Hennepin County judge, aren't you now? Aren't you the longest serving Hennepin County judge?
I am. So obviously I became a judge when I was young.
About 5 years old, is that it? How
Yeah,
many
yeah.
years? How many years has it been, though? How many years you've
Well, I
been
came on in
judge?
1994, so I think it's going to be 27 years this summer.
27 years. And so what we're going to do going forward is we're going to talk, and we'll use the some slides as well, but we're going to talk about what you just saw and also what should have happened, what constitutional protections should have been given, and we'll discuss those constitutional protections in the context of today without getting into any specific cases, that which we cannot do as judges, but we will talk about it more generally. I will add this, that the Equal Justice Initiative, Brian Stevenson, maybe some of you have seen the movie Just Mercy. That's about him. He has a museum in Montgomery, Alabama, and there's a lynching memorial there that's very moving as well, which has what looks like tombstones in essence for the 4,000 documented cases of lynching. There are many more, of course, that we aren't documented. And these three gentlemen from that were lynched in Duluth are, in fact, three of the people memorialized there. So I just raised that for you, and it's an excellent website as well that he has for Equal Justice Initiative. David, if we can get to the first slide, but if not, we'll just start anyway. Let me ask Judge Bransford, though, quickly here to start. What are some of the what rights did even Max Mason, who was in fact tried, of course, he did get a trial, but what were some of the things that jumped out at you of that were clearly unconstitutional that occurred? And lynching, of course, is unconstitutional, but what are some of the things that jumped out at you as being improper?
Well, one of the things is that every person in the United States has a right to be free from unreasonable searches and seizures, and which is under the Fourth Amendment. And in fact, as judges, they have to. Police officers have to go to the judges to get search warrants, and we're supposed to be independent magistrates, and we have to review all the information or evidence to determine whether there's enough for a search warrant. In the case that Mr. Blackwell just told us about, it seemed like Max Mason was free to go when he was, in fact, with his working and with his group of people getting ready to go to the next town. And it looked like he was just unconstitutionally seized and searched and questioned. So that's another thing. You're not supposed to be questioned unless you have the right to have an attorney, and you're not supposed to be forced to give confessions. And it sounds like they put a gun to his head and forced him to confess.
And and that would be things we hear. People should realize that happen in the United States of America. We hear about things like that happening in countries around the world and in past terrible regimes around the world, and here it happened right in the United States, and
unfortunately right in our own state.
In our own state, absolutely
Yeah.
not. When people say it only happens in Alabama or Mississippi, are mistaken. It happened here, and more than one occasion in terms of forced confession. Certainly, did one thing. Another thing that he has. You mentioned that we all see on television. You have the right. You have the right to remain silent, and so forth and so on.
Mhm.
But that wasn't the Supreme Court hadn't said that at that point in time. That
That's true.
in
The Miranda
1920.
case hadn't passed in 1920, so Miranda versus Arizona, right? So that wasn't there then, but it was part of the amendments that you had the right to have the Fifth Amendment was still there as far as no person should be compelled to be a witness against themselves. Also, he had a right to have a trial by a fair and impartial jury. So he had that trial, but we could talk about whether or not there was a fair and impartial jury there or not. I know one of the things that we're still trying to do, when I say we, I mean within the state of Minnesota and even around the country, but to make sure that juries are reflective of the true population of people that are there and not just, so we want to make sure that juries have people, African American people, people of all different ages, genders, races, ethnicities, so that it's more representative of the true jury of one's peers.
Yeah, there's a movie that is beyond way before the time of anyone watching this video, but you remember it, 12 Angry Men, and there it was about a jury, and all you really see is the jury.
Right.
Although we know the defendant is a person of color. We know that because we see him briefly, or at least perhaps
Yep.
Hispanic, but we're not sure. But in any event, the jurors are 12 white men.
Yep.
And that just goes to the point I think you're trying to make, and for a long time, African Americans in many states couldn't even serve on juries.
Right
Isn't that
there,
right?
we were totally excluded, but that's changed, and so now there's efforts being done to try to increase the diversity of jurors. I've heard that they're even trying to do that right now in the Duluth area, because of course we want to include Native Americans, indigenous people, and more people of different backgrounds on the jury.
Let's go to the next slide, David, if you can do that. Okay, so we began talking, and we'll go in some more detail here. We began talking about the Bill of Rights, and that's what Judge Bransford referred to, the Fifth Amendment. We'll look at some of these just briefly. You're entitled to due process rights. The 14th Amendment says, in essence, the way the Supreme Court has interpreted, that most of the Bill of Rights, the Bill of Rights are the first 10 amendments of the Constitution, apply to the states. In other words, the state has to give you those rights as well. And Judge, why don't you go to the next slide, David? Thank you. So the 14th Amendment, I'll get to the next one in a minute. You can even go to the next one from here, because it says nobody shall be deprived of life, liberty, or property without due process of law. So let's start with the Fourth Amendment, which Judge Bransford already mentioned. You can see what it says here: the right of the people to be secure in their persons, houses, papers, effects, against unreasonable searches and seizures shall not be violated. No warrant shall issue, but upon probable cause, supported by oath or affirmation, describing the place to be searched and the person or things to be seized. So, and that applies to the states. And
It
so,
definitely applies to the states. And I am a judge, a trial court judge, and we do review these warrants to make sure. One of the things that we check on always is to make sure that there is sufficient probable cause. The police
what does that
officer.
mean? What is probable? Sorry to interrupt you, but explain what probable cause means. When you get, you say you have to have probable cause. What is that when we sign those? What does that mean?
Yeah, that means that there has to be enough evidence that it's likely that there's a crime that occurred.
I see. And so we saw in the news recently that a former attorney to the former president of the United States, had his phone taken. And that's a type of search, isn't it? A phone or a computer, right?
Exactly. And so now, because of course they didn't have phones when they did the Constitution way back in the 1700s, but it says, persons, houses, papers, and effects. And so effects would include like phones, computers, all those kind of laptops, all those kinds of things are now things that could be searched, but they can't go and search and take those things unless a judge has signed off on the warrant to find that, like for instance, you have to make sure that you have the right location, that it's the right person, where it says describe the place to be searched and the persons or things to be seized. So just for instance, there might be cases where if someone thinks that someone's doing child porn or those kind of things, I don't know, but that might be on their laptop, then they have a right to go in to the laptop, seize the laptops, and search the information if they're looking for anything that would be on a computer, for instance.
And so it also says it must be supported by oath or affirmation. What does that mean? Tell the students what that means.
Well, that really means that the police officer, the investigating officer, whoever that is, federal, it might be an FBI agent, whatever, but they have to swear that it's true. They have to swear that the information that they have, so it's by
Under
oath
oath,
is
yeah.
swearing, or they have to affirm. So if they don't want to swear, but they have to affirm, which means promise, basically, that everything in that search warrant is true to the best of their knowledge.
And have you, as a judge, have you ever turned down, as a police officer, ever come to you in your 20s, what we say, how many years?
27 years.
27 years. Have you ever had to say, no, there's just not enough probable cause here. I'm not going to let you go search this home or this phone or whatever?
I have, but what happens more frequently is I've caught mistakes. And so that's why I think it's really good. When I looked and I said, okay, so look, the front of your warrant where you say you want to search and the back of your warrant are not the same address. Go back and get the right address, and then I won't sign it. And so they're like, oh my goodness. And really, to be honest, most times police officers are glad if I catch a mistake, but those are mistakes. Other times I've said, I don't understand what happened here. There's not enough probable cause. And then they'll start talking about more things. And I say, well, that's good, but you have to put it in writing. So if you really know, for instance, well, the types of ones that we get very frequently now are if they want to do a blood draw of somebody after someone's been driving, and especially if as a result of drunken driving or you're under the influence of a drug and someone got hurt or killed. And so they're in the hospital, they want to get a blood draw, and sometimes they've given very sketchy, not very much information. And I've said, there's not enough here. I'm not going to sign it. And then they'll tell me, because we're usually now on the phone, they'll tell me, oh no, we have more information, this and that. And I was like, well, I don't have enough right now. So I press the reject button and then they give me some more information. And if they have enough, then I'll then sign it, because they have to have enough to show that there's a crime.
We've heard a lot in the news about so-called no-knock warrants. What's that?
A no-knock warrant is when the police are able to go into a home or business without knocking first and announcing their presence. So usually they would have to knock and say, police, police, and then police here, and then the person give them a chance to open the door or something and let them in. If they do a no-knock warrant, it is usually because there's some kind of emergency or because they think that there would be guns or a violent response. They have some reason to believe that there's a lot of guns, or sometimes they've used them a lot, unfortunately, for when they think there's a lot of drugs, because they think that they would, they meaning the police, think that the persons accused would get rid of the evidence quickly, so they'd flush the drugs down the toilet or something like that. Those are the types of cases where we see them most frequently. But even if it's just drugs, it has to be some kind of thing saying that we think that there would be danger, that people have guns around, and that it would be dangerous to the police if they knocked and did a search warrant.
And those are scary because they could end up with somebody being seriously hurt. It could be even a police officer, but somebody could be seriously hurt in a no-knock warrant. And we've seen that happen. So judges have to be really careful, don't they?
Yes, and one of the things that we've been talking about among my colleagues, other judges, is that we ask additional questions. If they want no knock, we want to know more information. They have to give us more information. One of the things that we just started asking are there any children that live in that home? Are there any other, because we want to make sure that there's nobody else there that might get hurt that has nothing to do with the alleged crime. We want to make sure that
we saw something like that in another state, didn't we?
Yeah.
A famous case in their state. Let's go to the Fourth Amendment. Judge Bransford has told us there were some real problems with Max Mason's case there. Let's go to the next slide. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, and this is what Judge Bransford was getting at, of the state and district where the crime shall have been committed, which district shall previously ascertained by law, shall be informed of the nature and cause of the accusation, confronted with the witness against him, and to have compulsory process for obtaining witness in his favor, and have assistance at counsel. There's a lot in there, and this is a lot in that amendment, and this is goes a lot to what Judge Bransford said. You have the right to a fair trial, not a perfect trial, but a fair trial. And so let me ask her about a couple of these issues here, maybe taking them a little bit one at a time. First of all, Speedy, a speedy trial. Now he may have gotten a speedy trial. I don't remember how quick Max Mason's trial was. I don't recall that. And a public trial, but what does that mean? Speedy in public, generally.
Well, a speedy trial means that you shouldn't be sitting around waiting for months and months and years for your trial to come up. Um, there were some cases that were kind of famous in that are all done with in other states where a young man was waiting and waiting for 2 or 3 years for his trial,
In
and he
jail,
was
right?
in custody
In
in
jail. Yeah.
jail the whole time.
Mhm.
And it was so sad he finally had a trial. We don't want that. And unfortunately, we've had to really deal with that on a variety of cases because of COVID. So COVID has affected our ability to have trials. And so therefore, some of the people that are in custody that are charged have demanded speedy trial, and now we're trying to proceed with having the trials as quickly as possible. But the point is that you shouldn't be sitting for months or years in custody waiting to have your trial. And the exact number of days might differ by jurisdiction, but it's more like 60 or 90 days, and you could extend it, but it's a balance because you want the defense to have enough time to do their full investigation and to be able to fully present their defense. Although it's clear that the state is the one who has to prove the case beyond a reasonable doubt. The defense doesn't have to prove their innocence.
Okay, and that was an important point right there, that in a criminal case, no one's found innocent, and it's the state. No one's found innocent, despite what you all see on television. No one runs out of a courtroom saying, "I've just been declared innocent." But you're found not guilty, and so you have to be found guilty beyond a reasonable doubt, which is a very high standard. If I'm suing somebody, it's just 50%. If a car accident occurred, was the light red or green, and I'm just suing you about it, it's a 50-50 thing. If it's a criminal trial, it's beyond a reasonable doubt that it was red or green.
Which is a high standard,
High
the
standard.
highest standard that we have in the courts.
What about public trial? Can I shut the courtroom? I'm in a courtroom right now. Can I shut the doors in a criminal case and say nobody can come in and hear this?
No, we have to keep they have a right to an accused person has a right to a public trial, and that means that anyone should be able to come in and watch it as they can. And in fact, some trials now are also available that people could watch it remotely, like they're being live streamed, or they're on TV, because that allows the public to be able to see. But basically, we as judges get in trouble if we try to lock the courtroom doors or have secret proceedings. We can't have secret trials. They have to be open to the public. Now, the only exception to that is that some juvenile court cases where I'm working in juvenile court now are can be confidential and are supposed to be confidential. For instance, in Minnesota, if a juvenile has committed an offense and they're under the age of 16, they still have a right to confidentiality. So their parent or guardian could be present, witnesses can be present, but not the general public. That's an exception to the rule because of the fact that we know that young people can sometimes make mistakes, and we don't want the whole public to know about that. But for every other situation, and especially where they're adults on criminal cases, public means that anyone in the public should be able to just come in and watch the trial. In fact, sometimes in the government center where I work, there's some people who it seems like they just go from trial to trial to see what's going on, and they just come in and watch and see what's going on and go to another case.
Better than television. All right.
Right?
An impartial jury, and you talked a little bit about that earlier, that talking about the composition of the jury, but you're entitled to an impartial jury. So what does that mean? What if Max Mason probably did not have, it was probably an all-white jury that he had, almost certainly, and I don't know if he had a chance or not to find out if jurors were prejudiced, not against either him or his race, one or the other, because they knew about the crime. It was a famous thing that happened there. How do you handle that when we pick jurors? How do we make sure that jurors are picked and that they're impartial?
Well, impartial means that they have an open mind and that they haven't preconceived what they're going to do before they even hear the evidence. So we want them to have an open mind and to listen fully to the evidence to determine whether or not the state has met their burden of proof beyond a reasonable doubt. So one of the ways in which we determine whether jurors could be impartial or fair and open-minded is by asking them a lot of questions to determine whether or not they have any preconceived notions, like whether they think that all people of a certain race or all people of a certain whatever think a certain way or are guilty because of this. So you just have to ask questions and tease it out. But it's very important to make sure that you can ask those kind of questions. And sometimes they get questions in writing first, where they can answer a questionnaire and then the lawyers can ask further questions. I personally get really nervous on serious cases where if the jury's selection process only takes place in an hour or a couple hours. And there have been, I guess, there have been some famous cases, unfortunately, that have gone all the way up to the Supreme Court where people didn't have like where they got the death penalty and they didn't have a very long for jury selection to even determine whether they were a fair or impartial jury. So we want to, I mean, you want to take your time at the jury selection. They don't show that stuff usually on TV because that's not as interesting, but not on the TV shows that you see. But it's really important because we want to make sure that all the jurors are fair and impartial, that they have not already made up their mind before, or they're not swayed one way or the other, like they're always pro police or something like that.
And the location of a trial, can that sometimes be unfair? In other words, normally you're going to have a trial where the crime itself, alleged crime, was committed. But when does that sometimes? When do at least attorneys make the argument that maybe it should be moved somewhere else?
Well, if it appears that they cannot have a fair trial in the location where the offense took place, where the crime took place, the defense attorneys or the prosecutor, someone could ask for a change of venue, which means I want to move to a different location so that there would be a more fair trial because maybe the flames and the passions are too great at this place. Now, what we saw from what Mr. Blackwell said about Max Mason is that, oh, I can't remember what the percentage, but I think he said a large percentage of the people that even lived in the city of Duluth were all there at the lynchings. So they were all witnesses. So probably it would be difficult to get a fair jury there because they might have all been a part of the incident. So maybe they would have to move to a different location so you would get some jurors that hadn't been part of the witnesses or spectating.
Yeah, that's a good point about that case for sure. People, that mob was what, 10, 20,000. I can't remember. A lot of people. A
Right.
large percentage of the jury pool was actually out there for the lynching, and it was a very emotional crime and all alleged crime and all that, and might not be if the trial were held in St. Paul or something like that, somewhere
Correct.
like that.
Yep.
All right. You also have the right to know why you're being accused of something. It's not like there's a book that most of you students will not have read, but there's a book called The Trial. And in that one, the guy never knows why it's in another country. He has no idea why he's even in prison, which happens in other countries. You need to know that. What about confronting the witnesses against you and being able to call your own witnesses? What about that?
Well, that says that you should be able to confront or question any of so an accused person, so the person that's being charged with the crime, has the absolute right under the Constitution to confront or question any of the state's witnesses against them. And you see that on TV or on different movies, which is called the right of cross-examination, to see whether or not the people who are testifying are accurate in their testimony. Did they really see, hear, or see or witness? Do they have some bias? Are they wrong about their testimony? So the lawyer for the accused would be able to flesh all that out and find out. The lawyer also has a right, the defendant, the person being accused, has a right to bring their own witnesses. And you can think of those more often like in an alibi situation. For instance, they might say, It wasn't me. I was in another part of town. I wasn't even in that town. I was, I was doing something else. And I've really seen that happen before, but hopefully that happens before you get to trial. That if you have enough evidence to show that it wasn't me, I was, I have all these other people, like I was at work. I was at work. There was people at work that can verify I was at work, not wherever this crime allegedly took place. So that it wasn't me, it must have been somebody else. So that would be an example where you'd want to bring in your own witnesses. Although again, the defense does not have to bring in witnesses, but they might have witnesses that could say things that would be helpful to their side of the story to show the jury that they're not guilty.
And we or and assistance of counsel. We've already mentioned you can't be. I think we mentioned, and also we can't make a defendant testify against himself, can we?
No, you cannot. They have the right. You've probably seen that before where someone says, I want to take the fifth or whatever. That means that if they're accused, you can't force them to testify. So they can remain silent, and the judge or jury cannot use their silence against them to assume that because they're silent, they must be guilty. So you can't use that against them at all. And it also says that they have the right to have assistance of counsel for their defense. I believe in this case, Max Mason, that he had a lawyer from the NAACP, which is the National Association for the Advancement of Colored People, and that organization had been around for over 100 years. So they provided an attorney, but it wasn't until later with some other cases that the United States Supreme Court said, hey, everybody that's accused of a crime, of a felony at least, should have a right to have an attorney. And if they can't afford their own attorney, they should be able to have an attorney at no cost of theirs. Gideon versus Wainwright and some other famous cases.
Yeah, and in Minnesota, felonies more than a year in prison.
Yeah.
In Minnesota, you're even entitled for a misdemeanor less than a year in prison to have a public defender if you can't afford one. Not true in some other states, however. So,
Yeah, which is really too bad because you wouldn't, even if you wanted to go to, if you were found guilty and you had to go to jail for even 6 months or 3 months, that could still make you lose your job or do a whole lot of other things and disrupt your life.
Okay, next slide. The Fifth Amendment, we've kind of already talked about that, and that's that no person shall be held to answer for a capital or otherwise infamous crime unless on indictment of a grand jury. We'll talk about that in just a second, because that doesn't, the application of that is not as universal. Nor shall any person be subject to the tried for the same offense twice. We'll get to that in a minute. Twice, if you've already been found not guilty, that is, and you can't be compelled to be a witness against yourself. We've already discussed that one. Let me get to what we call the double jeopardy, meaning if you're found not guilty, can the state keep trying you over and over again until they finally get a conviction?
No, they cannot. And that is called double jeopardy. So once you've already been tried for the charge, for the crime, if you were found not guilty, they can't go back and say, let's try again. Now, the times where they've had repeat trials are if the jury was hung, or if, meaning they didn't reach a verdict.
Because they have to be unanimous, correct? And then so if they're not unanimous, then it's a hung jury, right?
Right. Yeah. So if you don't have 12 jurors that all agree, if you only have like 9, or even if one doesn't agree, but it has to be unanimous verdict. So those are the only types of situations where you would have a retrial on the same charges.
So I literally, if someone's found not guilty, they could write a book called "I Did It." Now, that wouldn't be advisable to do that, but because you could still be sued civilly, for example, and
Right.
so there's still penalties, but technically you could do that and not be tried for the crime. I'm going to skip on. Let's go to the next slide. We'll skip on grand juries, except grand juries, sometimes that's jurors who actually decide to charge the person, as opposed to the prosecutor doing it themselves. The Eighth Amendment says excessive bail shall not be required, nor excessive fines, nor cruel and unusual punishment. But let me get to the bail. Let's talk about that. So what is bail, and in Minnesota, is it required? And what happens if somebody cannot pay the bail? Maybe you can just quickly discuss that.
Yeah. So you've in Minnesota, it says, and because We have our own Minnesota Constitution, and it basically says the same thing as this is from the US Constitution. But you're not supposed to have excessive bail, which means really high bail, shall not be required. And what that means is that basically you should try to see if the person will come back to court. So we want to know two things. When we advise judges and we're looking at bail, we want to know, number one, are they going to return to court? And number two, are they going to commit a new offense? And so we want them to come back to court without being charged with a new offense. We have to remember that they're presumed innocent of the charges until and unless they actually have the trial. So bail is pre-trial. So they haven't been determined to be guilty of anything. It's just to get them to the trial. We want to make sure that judges don't set bail really high so that people can't get out, because that obviously is unfair, because that would mean that people that have more money could afford to get out of jail by putting up bail, like say bail is $10,000 and they could post the $10,000 bail, but someone that doesn't have the $10,000 couldn't. And so even though they're charged with the same offense, the person that has more money gets out and the person that has less stays in custody while they're waiting for their trial. So
And lose
that's
their
what the
job
difference
and
is.
all that kind of thing, as you mentioned
They
earlier.
can lose their job, they could lose custody of their children, they could lose their housing if they can't afford, if there's not someone else that can pay, if they have rent or their mortgage or whatever. So they could really lose a lot, and they haven't even been found guilty. And so what if they had a trial and they were found not guilty? So
And bail's controversial is because some people can afford it and some can't. So maybe poorer people end up being in jail waiting their trial, and maybe they'll plead guilty. Pleading guilty means a lot of people just plead guilty and get
in
done
order
with
to
it, not
get
trial.
out,
They
it
might do
means
it just to get out, to go to their job, right?
And that's correct, Judge Fisher. I didn't mean to interrupt, but there's been data that have shown that if people are in custody, they're more likely to plead guilty than if they're out of custody. And so then you wonder, are they pleading guilty because they really did it, or are they pleading guilty because they just need to get out of jail? And so, and that winds up being more poor people or more people of color, unfortunately, that might not be able to afford to pay that bail. Even if you've heard of bail bondsmen, so even if we have bail bondsmen, they might not have the collateral. That means that somebody else, you have to pay like 10%, but then you have to have some other proof or other good source of money to come up with that.
Like your house.
Like your house. But what's happened is that there's recently been bail reform, and some, like in California, their Supreme Court just recently did a decision that said, judges can't just set bail without considering strongly whether the person can afford to pay the bail. And some states have gotten rid of bail altogether. They've removed it from their state constitution, like New Jersey, and said, we're just going to treat everyone more fairly. And it looks at how serious the crime is and whether or not they're likely to return to court, and not whether or not they can afford to pay.
In the last minute we have, what's the lesson of the Duluth experience, the Duluth thing we just learned about? Even thinking about today, what do you think students should learn from that?
Well, I think it was really hard, to be honest, to see that. But I think the important thing is to note that even though that happened over 100 years ago, we have to make sure that we enforce people's rights, their right to be free from searches and seizures, their right to make sure that we are treating everyone fairly and everyone gets a fair trial. And so I think we want to make sure that the passions and the hatred that was so clear in the lynchings of those three African American men, Clayton, Jackson, and McGee, is not. We want to do whatever we can do as young people and as adults to not have that kind of hatred that could continue into today.
And all of us try to stand up for the rights of others, even if we're not judges or attorneys, right? I think that's another lesson, don't you
Exactly. I
think?
think that we can do that people, in fact, young people are doing that all the time, standing up for the rights of others, to making sure that everyone's rights are being that no one's jeopardizing their rights and that they're being enforced.
Well, we are out of time now. Let me just give you, I'm going to give my phone number out. And if anybody wants to talk to me or Judge Bransford, you can call me 651-848-1060. I know how to get a hold of her. 651-848-1060. Thank you, Judge Bransford, very much for doing this. And thank you, students, for watching.
Thank you. I'm sorry I couldn't see you. It's weird doing this when you can't see the students, but I hope you got something out of it.
Okay. All right. Goodbye. Thank you.
Bye-bye.
Thank you, everyone.
Thank you. Thank you, Cassie. All right. Thanks again, Tanya. All right. Goodbye.